The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome, counsel, and welcome to all of those who are watching on our YouTube Supreme Court Live channel. I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the 11 o'clock docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Tuesday, September 14, 2021 consists of one case. Appeal number 120329, Don Herrington et al. Versus the City of Wichita and City of Wichita Police Department Officer Randy Williamson, Sedgwick County, briefs both sides. This argument is scheduled for 20 minutes by each party. The appellant has reserved 5 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
Thank you, Madam Chief Justice. James Thompson appearing on behalf of the plaintiff appellant, Don Herrington.
May it please the court, David R. Cooper on behalf of the defendant and appellee City of Wichita. Officer Williamson is not a party to this lawsuit any longer.
Thank you, counsel. Mr. Thompson, you may begin with your argument.
Thank you, Madam Chief Justice, and may it please the court. I think it's important for us to take a few moments to talk about the facts of this case. This case arises out of the shooting death of Troy Lanning by Wichita Police Department Officer Randy Williamson, who was then later terminated after being involved in another shooting, his ninth shooting. The plaintiff in this case is the mother of Troy Lanning, and she filed claims in both in federal court of both federal claims and state law claims. The federal claims were civil rights violations. The state law claims included wrongful death, negligence, and some other claims. The case proceeded through the federal court. We did complete full discovery in that case, and then we went to pretrial. The defendant filed a motion for summary judgment asking that all of the claims be dismissed for various reasons. The federal court, when it wrote its opinion, looked at the different claims, and it found that the plaintiff had cited evidence that a reasonable jury could find that Williamson had violated Mr. Lanning's constitutional rights, but because plaintiff could not cite to a 10th Circuit case or a Supreme Court case, qualified immunity applied, and therefore the federal court dismissed the federal claims. The timing of when those federal claims get dismissed and the state law claims is important, we believe, in this case. Now, the federal claims were dismissed, and so this court went on to say that after dismissing the federal claims, the timing, having considered the nature of the state law claims and the circumstances of the litigation, the court concludes plaintiff's state law claims should be dismissed without prejudice. Citing 28 USC 1367 C3 and stating that the court may decline to exercise supplemental jurisdiction over a claim if the district court has dismissed all claims over which it has original jurisdiction. So again, the timing there is important. The federal claims are dismissed first, and the state law claims are dismissed second without prejudice. The plaintiff then went to the state law court, filed the same state law claims, and the defendant in response filed a motion for summary judgment asking the court to dismiss those state law claims based on the Stanfield v. Osborne and Roden v. Dixon decisions. The state law court granted that motion, finding that Stanfield and Roden did apply, and therefore res judicata would step in and bar plaintiff from filing her claims in state court. We then filed the appeal. The Court of Appeals in its decision affirmed that trial court's decision, but noted that the plaintiff has never had an opportunity to have her state law claims heard. They've never been heard on the merits. And then, of course, Judge Atchison wrote a concurring opinion, a very lengthy concurring opinion, I would say, on why Stanfield and Roden should be overturned and why res judicata shouldn't apply. And so we come before the Kansas Supreme Court asking you to please overturn the Stanfield and Roten decisions because we believe that they were misguided when they were decided. Even though they reached the right results, the resulting case law has resulted in hundreds of plaintiffs, including my client, being denied the opportunity to have their state law claims heard once they've been dismissed in state court. The first issue that I'd like to talk about is we believe, as Judge Atkinson pointed out, that the decisions in Stanfield and Roten violate the supremacy clause of the United States Constitution, because we've got 28 USC 1367, Rule 41, and then several Supreme Court cases. We believe that if the Kansas Supreme Court had followed those cases, would not have resulted in the decisions that we had hand down at Stanfield and Roten. 1367 allows a federal court to dismiss dismiss state law claims if the federal claims are no longer in the case. In our case, for example, the federal court, I'm sorry, did somebody ask a question? Oh, the federal, my apologies. The federal court had dismissed the federal claims, leaving only the state law claims. And so in the second part of its order, it specifically said it was dismissing without prejudice. 1367 C3 states that if a claim is dismissed for jurisdictional reasons, it's going to be dismissed without prejudice. With Rule 41, it's much the same issue, that we have a involuntary effect. And so it states, unless the dismissal order states otherwise, a dismissal under the subsection B, except one for lack of jurisdiction, is an adjudication on the merits. So in this case, we have the refusal of the federal court to exercise its supplemental jurisdiction. So it's a jurisdictional issue. So again, it's a dismissal that is not an adjudication on the merits. And then we believe when the court looks at
counsel, can you walk me through that analysis? What is it about our rule in Kansas that undermines or conflicts with 1367 precisely?
I will try to do that, Your Honor. Justice Wall, with the Stanfield decision, we had an analysis that was done by Judge Abbott in that case, in which he went through and relied heavily on the restatement of judgments, second, and it was sections 24 and 25. What we believe Judge Abbott failed to do in that was then to go on and analyze section 26, which addresses the issue of when you have a case like ours where the case gets split, and it says that if the case is dismissed for lack of jurisdiction, then those claims should not be barred by res judicata, even though the federal claims were. And I'm paraphrasing here, but that's essentially what that says. I think it's important too, Your Honor, on that note, that if we look at the plain language of these, that we have a dismissal without prejudice, it means just that, without prejudice. To say that it's a dismissal without prejudice, but, oh, sorry, we're going to prejudice you by not allowing you to refile the claim, well, then it's not a dismissal without prejudice. The Kansas rulings in Roten and Stanfield are the only courts in the entire country that follow this line. We have seen in all of the different briefings where we all talk about the transactional approach, and that's what Kansas follows. But the results that Kansas reaches is different than any other court in the entire country. And so to say that 1367 allows for the dismissal without prejudice, then we file in state court, and the court then says, oh, sorry, King's X, because of Stanfield and Roten, we're going to not allow you to file this. The state court is then imposing its definition or its rulings on res judicata over that of the federal court and the U.S. Supreme Court, which, as talked about in our briefs and Judge Atkinson's decision and the NELA briefs, we believe is a violation of the Supremacy Clause. Does that answer your question, Justice Wall?
Well, I think maybe, but my understanding was you were sort of relying on artists and the statute of limitations component in subsection D, that somehow that maybe implicitly suggests that if you're going to extend the statute of limitations period on these types of claims that come back to state court, then of course it's implicit or inherent then that the intent, at least at the federal level, is for the rule of preclusion not to apply. Is that a fair summary or characterization, or?
Well, Your Honor, I think in Artemis, it specifically says that if a district court declines to exercise jurisdiction over a claim under 1367, the plaintiff wishes to continue pursuing it, she must refile the claim in state court. I think that that's a clear indication of where the Supreme Court believes any normal dismissal without prejudice would head. And I think that that's clear also in looking at every other court in the country, that when you have a dismissal without prejudice, when the issues that were raised have not been heard at all, that's the case. In this case, we don't have a splitting of the claims by my client. We filed everything in federal court because there were federal claims. The defendant has asked to say, well, okay, the federal claims got dismissed, the state law claims got dismissed without prejudice, but you can't refile those in federal court now because we don't have the federal claims. Therefore, it's a dismissal with prejudice. And we think that that's just an unfair, unjust, and unreasonable reading of 1367C and just the plain language of what it means to dismiss without prejudice. I think it's important to note that when you're looking at these cases, that neither the defendant nor National Association of Defense Counsel were able to produce a single case anywhere in the country where the same results are reached. We just don't have that. We are an outlier of one in Kansas. And so while the decisions in Stanfield and Rhoton, I think were correct in the results that they reached, and that with Stanfield, you had 3 different cases filed over 20 years. That decision is right as far as that person should not have been allowed to continue with those claims. With Rhoton, Justice Biles, you wrote this decision relying on Stanfield, which again, Stanfield goes back to that restatement of judgments 24 and 25, but then fails to take into accord or into account Rule 26, which talks about this specific situation that we're in now, where we have claims that have never actually been heard, and my client will never get a chance to hear those, have those claims heard or decided. And so that becomes an issue, not just for my client, but numerous clients are losing their state law claims because of this.
Counsel?
Yes, Justice.
I understand I think pretty clearly, and I think you make a compelling argument that, hey, this just isn't fair. And we do know from our long res judicata case law that it's an equitable doctrine that we apply case by case to, vindicate the underlying interests, and so on. But I'm struggling with your supremacy clause argument, because it sounds to me like what you're saying is that the federal courts can basically force Kansas courts to open up and hear a case. And I guess I just am uncertain how you stretch the supremacy clause that far.
Well, Justice Sigel, the history or the precedent that we have here is that when state courts are applying res judicata based on a federal court's decision, we have to apply federal law. And that federal law says.
Can I stop you right there?
Yes.
Do you have any case that says that? I mean, this is res judicata is a state common law doctrine, right?
It's a common law doctrine, I think, across federal and state law. But
when it's a state court lawsuit, we're applying state law. We're not applying federal res judicata law, are we?
well, but I think we are, Your Honor. I think that when you look at, I think it's United Mine Workers v. Gibbs, Heck v. Humphrey, and others, that when you have a federal case that's dismissed, you apply federal law on res judicata, the effect of res judicata. And in this case, we have plenty of law from around the country at the federal level and the Supreme Court's own decisions that say you have to follow the federal law on this. And I think that that's in United Mine Workers and Heck v. Humphrey. I think that's implied with Artis that we had already discussed. And so I think there is case law out there, Your Honor. And I think also if the court looks at Judge Atchinson's decision, he lists a long line of cases all across the country where that premise comes up, I think. So it is a federal issue, I think, in that we have to apply what the federal courts mean by their dismissal without prejudice. And in this case, that dismissal without prejudice means just that, that the client, my client, should not be prejudiced by that dismissal. The federal court in this case even specifically stated that the ruling it made was made after consideration of all the state law claims. And I'm sorry, Your Honor, I just saw that I'm out of time now. Unless there's other questions, I will end there. So
I've got one. I want to push back on the notion about fairness or unfairness. I mean, it seems to me with Rhoton and Stanfield being the law of Kansas, you knowingly filed your lawsuit with state law claims in the federal court. So you were on notice that if the federal court didn't address those claims by refusing to take on the supplemental jurisdiction, the law as it existed at the time you filed the lawsuit said that you would not be able to run to state court and do this all over again. So how is it unfair, given the fact that you picked your forum and then you litigated the case in federal court, and it didn't come out your way? The defendant now is saying, wait a minute, we've got to come back and relitigate in state court the same claims we just dealt with in federal court. I mean, how is that fair to the defendant?
Your Honor, I think, appreciate your question. And I would argue a couple of issues there. One, we did have a choice between filing in state court or federal court. The result is the same, though. If you file in state court and it's removed to federal court, the city of Wichita has a case right now that they argued Stanfield and Rhoton in that is actually pending judicial review by you at this moment in Williams v. City of Wichita, in which they argued Stanfield v. Rhoton and had the case dismissed. So the choice there really wasn't a choice. We were faced with it either way, based on what we were seeing.
But we don't know how that case is going to come out, but at least I don't know of any. My understanding is that from what I've looked at, that we do not have any application that we have decided of the Rhoton-Stanfield line that was not a case brought initially in federal court by the plaintiff. So, let's not say you didn't have a choice. We don't know what that law is we don't know what that result's going to be. But, and I think there's an argument in the briefs that you would not face that problem. But again, how is it unfair when you knew what you were getting into and you picked your path?
We picked our path, and we're asking the court to reverse what is essentially what we consider to be bad law at this point, Your Honor. We believe it violates the supremacy clause. We believe that it's unfair because you have a dismissal without prejudice. Now, I understand your argument, Justice Biles, and I think even you commented in Roten that it can produce unfair results, but sometimes that's just part of dealing with res judicata, I believe was your ultimate conclusion on that. We're asking that the court reconsider that, because at the end of the day, it should be the court's role to make sure that we have a fair result. And when my client has not had those claims heard, it becomes an unfair result for clients like mine when they can't have their state law claims heard because of this outlier of Stanfield and Roten.
Couldn't they have had the claims heard by filing in state court first?
Your Honor, my experience in filing these cases is that anything you file in state court gets removed to federal court. And so we filed in federal court.
And if that had happened, would we be here now under Stanfield and Roten?
Well, again, considering that Williams, the city of Wichita, which I'm also counsel in, is waiting to find out whether or not you're going to review it because it got thrown out at the state court level and the Court of Appeals has now ruled. I think that we would be here.
I just mean that procedurally, if you file in state court first, it gets removed to federal court. The federal claims get dismissed. Don't you still have a state court action? And you're not running into your res judicata problem? Or do I have that incorrectly?
Your Honor, my understanding of it is that you are incorrect in that. And at least in my experience with it dealing with these cases in the past, that's what I have seen. And so
your point is that it really is unfair to your client. At least this is your argument, because even if you had filed in state court first, you'd still be in the same basic position.
Yes, Your Honor. Damned if you do, damned if you don't, so to speak. So, pardon my language.
So the remand back to state court in that situation does not change whether or not Stanfield Roten applies.
That is my experience, Your Honor, with the Williams v. City of Wichita case, where I'm also counsel and we face the same result.
Other questions?
Thank you, Your Honor.
I would just note that it appears Justice Standridge might have had an internet issue and we lost her. I just assure counsel and others that the recording is available to her for her to be able to go back and pick up the portion of the argument that she missed there. Mr. Cooper, you may present your argument.
Thank you, Chief Justice. I'll begin with just the statement that Stanfield and Roten does not create or did not fashion an eccentric or unfair rule of res judicata. In fact, they are a straightforward application of federal preclusion law. And
Mr. Cooper, I'd like to start with that. So I know it was raised earlier when opposing counsel was talking, but is it true that this court must apply federal law under Heck versus Humphrey? Because the issue here is whether state law claims are precluded by a federal court decision.
The first part of your question, the answer to the first part of your question is yes, federal law controls here. Whether it controls because of state law application, I don't believe that to be accurate. Federal law controls because the supremacy clause and Heck v. Humphrey, Simtech, and Gibbs all require that state courts apply, give a federal, full faith and credit to a federal judgment. And if a federal judgment or if a federal court reaches a judgment on the merits, all state courts must give that judgment the same preclusive effect as would the federal court. So I'll revisit this later, but it's a very simple question. Can plaintiff refile this lawsuit in federal court.
And what's that answer based on Gibbs?
On Gibbs and Semtec, the conclusion is that that state courts are not free to ignore the preclusive effect of a federal judgment and must give that federal judgment the same preclusive effect as would a federal court. Now, in Semtec, the Supreme Court didn't reach the issue of the preclusive effect. In fact, it said it's not automatic. You're going to have to determine whether, because in that case, it was Semtec was a diversity case, and so the preclusive effect was that of a state court, not that of a federal court. And so the Semtec Supreme Court actually reversed, holding that they had to give it preclusive effect, and they sent it back down, remanded it for a determination as to whether California law or state law would give preclusive effect to a dismissal based solely on the statute of limitations.
Okay, so, but Stanfield and Roten, in this case, none of them rely on diversity jurisdiction, is that correct?
Correct. These are all these are the court. The federal court had original jurisdiction over these claims.
And given that federal law must apply, in Gibbs, a state law claim said a state law claim that's dismissed in federal court for lack of jurisdiction should be litigated in an appropriate state court. Needless decisions of state law should be avoided both as a matter of comedy and to promote justice, right?
Yes, Gibbs said that, and the very important fragment of that sentence that I want to emphasize is when a case is dismissed in federal court for lack of jurisdiction. And this is not a dismissal for lack of jurisdiction. The federal court had subject matter jurisdiction, had personal jurisdiction over all the parties to this case, reached a judgment on the merits of this case, and a court deciding to decline to continue to exercise supplemental jurisdiction under section 1367 C3 is not a dismissal for lack of jurisdiction. The court has jurisdiction. The court has the discretion to continue to exercise jurisdiction or decline to exercise jurisdiction. And I want to pick up on what Justice Biles said, which is when you go to federal court with when you have a state law claim, knowing Stanfield and Roten are out there, you are picking your forum, and you are picking your choice of forum has consequences.
Okay, so under supplemental jurisdiction, which is what you're saying, that the district court can decline to exercise supplemental jurisdiction under 28 USC 1367. Under subsection C3, the district court has dismissed all claims over which it had original jurisdiction, right?
That's accurate, but it's not a loss of jurisdiction.
Right. But under 1367, as Justice Walls noted, there specifically is in 1367, it was expressly crafted to prevent a defendant from interposing a state procedural bar, right? Because they made it statute of tolling of the statute of limitations, right?
No.
No?
Short answer is no. A dismissal can result from a lack of jurisdiction, and a plaintiff can have lost their statute of limitations before the federal court reaches a judgment on the question of jurisdiction, whether it's a standing issue or whether there was simply a federal question presented at all. And 1367D, which is what you're referring to, simply provides a tolling provision that a plaintiff will not be presented with a statute of limitations bar simply because the lawsuit was first filed in federal court. That doesn't have anything to do with the effect of the preclusive effect of the judgment on the merits under Rule 41B of the Federal Rules of Civil Procedure. Any dismissal other than for lack of jurisdiction, lack of a joinder of a necessary party under 19 is a judgment on the merits. And
Why would Congress, sorry,
Nope, Justice Wall, go ahead.
well, why would Congress enact that provision in that situation if there's preclusive effect as a matter of law? Are there other circumstances that subsection D contemplates here that might give meaning to that subsection? Does that question make sense to you?
if you're referring to subsection D and not subsection C, I believe so. And it's just a
Yes.
circumstance where they realize that an action can get filed in federal court on the eve of the statute of limitations. And it may be literally years before the federal court adjudicates that issue. And subsection D preserves the right that if the case is dismissed otherwise than on the merits, the case gets to go back to state court without a statute of limitations bar. One of the comments that I was gonna make at the front end is this case is an oddity in that I'm arguing the same issue on the same side of the V in front of the same tribunal, a little over a decade apart. And I will tell you that when I first discovered Stanfield and the rule in Stanfield, I also thought, well, that just ain't fair. But when you actually dig into the law and dig into federal claim preclusion law, how Kansas applies claim preclusion law, it is an accurate and appropriate application of preclusion law. Because if it is a judgment on the merits, and there's no dispute that in this case that the federal court reached a judgment on the merits, and the dismissal was not a dismissal for lack of jurisdiction, state courts under the supremacy clause, under Heck versus Humphrey, and under Stanton and Roten have no choice but to apply the same implicit effect. Justice,
can I dig into that point a little bit again? And hopefully I'm not sounding like a broken record, but I'm really trying to figure out whether we're applying federal or state law here. And as I read Heck, it is not as broad as what the discussion has been, but correct me if I'm wrong. Heck says that state courts are bound to apply federal rules in determining the preclusive effect of federal court decisions on issues of federal law. That doesn't, as I read it at least, it doesn't loop in questions of state law. And in fact, in Roten, when we were discussing that rule, the Roten court said that the distinction's academic because Kansas law and federal law are basically the same. So it's unclear to me whether Roten was applying federal or state law. And to me, that's actually quite important in resolving this appeal, because I can see a situation where federal law may not require a preclusive effect, but as a matter of state law, res judicata could apply, regardless of what federal law says. I just would like to get your thoughts on that. And then for Mr. Thompson, he can think about, I'll probably ask him the same question later on.
That's a difficult question to answer because it's both. Because state and federal law are the same on claim preclusion, it's an application of federal law and state law, but is it being applied because of federal? The question is, can this plaintiff file this action in federal court again? And that's the point that I point out in Simtech as well, with respect to what is the meaning of a dismissal without prejudice. And a dismissal without prejudice is the ability to bring that lawsuit in the same court a second time. And there's no question that this plaintiff cannot bring this lawsuit in federal court a second time. And because it's precluded there, it's precluded here.
Well, and the reason this matters to me, and I may just be the only one who thinks about it this way, I don't know, is that your answer that it's both federal and state doesn't help me very much, because this court has the power and the legal authority to change Kansas law, but we don't have the authority to change federal law. We're bound by United States Supreme Court precedent on federal law. And this is a case that mixes questions of stare decisis with these doctrines of res judicata. So I'm just trying to discern how much discretion this court has to depart from our Roten and Stanfield holdings.
Okay. I say it's an application of both state and federal law because they're the same. And if you pose the hypothetical, Justice Stegall, that Kansas law might change in that regard, then it becomes purely a question of federal law as to whether these Kansas courts are required to give full faith and credit to a federal judgment. And there the supremacy clause does kick in. And I go back to my previous answer, which is if this plaintiff can't file this lawsuit again in federal court, it is precluded, and the supremacy clause would require that the states apply federal preclusion doctrine. And the briefs do have the briefing and illustrate the fact that there really is no substantive difference between how Kansas applies res judicata claim preclusion compared to that of the federal courts, whether in the 10th Circuit or at the Supreme Court level.
Let's say whether we're talking about federal law or state law, Stanfield relied on a federal case that's let's see. Stanfield relied on Petro Management, a 10th Circuit case from 1988, which adopted the transactional approach. And this transactional approach is set forth by the Restatement of Judgment, Section 24. So Stanfield relied on 10th Circuit law in saying that federal law applies, whether that's right or wrong. And then that federal law relied on the Restatement of Judgments for purposes of third element. But as you know, Petro Management, was different in the sense that it was a successive diversity action. But my question is, even though, if everything is kind of grounded in its Restatement of Judgments of 24, why isn't the Restatement 26 create an exception here?
Because Restatement 26 says that there's no res judicata effect where the dismissal is based upon a lack of jurisdiction. There's not a lack of jurisdiction.
Okay, would you say right now that the federal court has, so you're differentiating between pendent jurisdiction, the discretion to keep a case, even though kind of all principles say, we even have a couple cases. We have Judge Milgren, who said, somebody's even holding a case up there because they're like, well, this should be a state law issue, but the state law is not allowing to come back down. But you're saying there's a difference between, I'm sorry?
It's Judge Crabtree and the Dorfman versus.
Oh, I'm sorry. Yeah, thanks for correcting me. But you're saying there's a difference between, this whole discretion to dismiss, because now they couldn't, there's no diversity of jurisdiction here. So it's not like, you're saying, well, it was dismissed without prejudice, so they could go back to that court. But they can't, can they? Because it was based on supplemental jurisdiction, not original jurisdiction.
Yes, the basis of jurisdiction very much matters. There was discussion, and I guess we should go there so that I don't run out of time without addressing it. There's the question regarding the Williams case and the effect of removal of a case originally filed in state court versus a case, an action filed in the federal court in the first instance. And Justice Wall, Justice Stegall, you are correct in that a case that is removed from state court to federal court that results in a dismissal and the declination to exercise supplemental jurisdiction should result in a remand. The Williams case is unique in that the federal court, instead of issuing a remand order, issued a dismissal order, and that dismissal, which in my view is an abuse of discretion to decline to continue to exercise supplemental jurisdiction, was not appealed, and it merged into the judgment.
Why do all the other courts, why are we an outlier here?
I think we're the first ones to read the rules and apply them the way they're written.
So even the US Supreme Court hasn't read the rules and.
Well, nobody has presented this issue to the United States Supreme Court. And in fact, I can't find a decision anywhere else in the country that applies this distinction. Everybody did what, frankly, everybody did up until the Stanfield decision came along, and I discovered it again when I was litigating the Roten case. And I just assumed that a dismissal under 1367C really did not allow the application of claim preclusion. And as I said, dug into it, read deeply, and became convinced otherwise, that it is in fact a bar, and it's going to be a new body of law that I imagine, but I would imagine we're going to see a host of cases where this sort of dismissal gets appealed on the basis of an abuse of discretion, where if a federal judge, knowing that the state law claims are going to be lost if they dismiss them under 1367C, that would be, in my view, an abuse of discretion.
But you'd never have a chance to review that. The 10th Circuit wouldn't, because you have 30 days to refile. I mean, you've already missed your deadline, right?
No. Well, if they do not appeal to the 10th Circuit and resort, Roten in and of itself, that case was simultaneously appealed to the 10th Circuit and refiled in state court.
Right, but not on the dismissal. Was it appealed based on the dismissal based on the discretion under 1367?
They did not raise that issue. They raised the issue of the propriety of the dismissal of the federal claims themselves.
Let me ask you another question that just occurred to me. But if it was dismissed based on qualified immunity, which is a defense that you have to bring up before you even, I mean, that's what you bring up right away. And that's why. Okay, so it was based on qualified immunity. Would you count that as on the merits?
It is.
Okay.
The federal court do as well.
Because the merits of the claim weren't addressed, right? It just was.
The defendant's entitlement to immunity was addressed on the merits.
Mr. Cooper, let me, I'm not terribly hung up on stare decisis, because to me, as I wrote in that Roten decision, this is an application of federal law. So, if I got it wrong, I got it wrong. But what would you cite me to as a case that shows us the application of federal law for your side of the argument?
The Gold case, the 10th Circuit Gold case, the Nwasong case, Heck versus Humphrey, and Simtech, which points out that, hey, if it's a dismissal on federal grounds, states will give full faith and credit to that dismissal. If it's not, and it's not a federal issue, then we'll leave it to the states.
Doesn't Gold say that when a federal court declines supplemental jurisdiction under 1367, quote unquote, the proper course of conduct is to dismiss the state law claims without prejudice in order to permit them to be brought in state court?
Yeah, again, and the question is whether that is a dismissal for lack of federal jurisdiction or not. And I think that body of law and that statement is premised upon an idea that there is no preclusive effect, and that premise is incorrect. And again, all of this is remedied by starting this case in the state court in the first instance. And I do want to be clear, you don't file two actions. You don't file one in state and one in federal and hope that because the first one to judgment is going to be preclusive to the second.
And is that why the counter situation where there's a removal, dismissal on the merits of the federal claims and then a remand back to state court, is that in that situation, there is no dismissal on federal grounds that would invoke this whole doctrine that you're relying on for a claim preclusion?
I have to parse that. I have to rephrase that, formulate that question a bit, Justice Wall, because if it is removed and then the federal claims are dismissed and the case remanded, that is not the conclusion of the case in its entirety. It is simply sent back to the court of origin. So it is not a full dismissal on the merits. It's not a judgment on the merits that disposes of the entire claim. It leaves part of it open to be adjudicated in the court of origin.
And I guess my point being that that's what distinguishes that fact scenario from what we have here.
True. Also, that's not to say preclusion doctrines don't have any place or effect, because issue preclusion will then become the matters that would be subject to litigation as to whether they would bar certain issues and whether that issue preclusion may be preclusive of the entire claim or not.
So in a situation like this, your position is that the qualified immunity even should have been resolved by a state court judge in Wichita, right?
Could have been had the action been brought there in the first instance, yes.
Well, it's your position that it should have been if they wanted to keep their state law claim.
I'm not sure that I understand your question, Justice Sanders, because this case was brought in federal court in the first instance.
But I'm saying if this court had, if the plaintiffs in this case had brought their action, which was 70% federal and 30% state law claim, and then the whole issue about 11, or I don't know whether it's 11th Amendment, qualified immunity or whatever it is, all that should be done by the state court district judges, even though it's federal constitutional law.
It can be, because state courts are courts of general jurisdiction and can address all those federal claims. Seeing no other questions, I'm out of time. Again, I believe I ask the court to sustain and affirm the dismissal by both the Court of Appeals and stand by its prior decisions in Stanfield and Roden.
Thank you, Mr. Cooper. Mr. Thompson, you reserve 5 minutes.
Thank you, Chief Justice. I appreciate it. In answer to one of your questions, I can't remember which one of you asked it, but there was a discussion about whether or not plaintiff can refile in federal court. And the answer is no. But the reason why is because the federal court no longer has jurisdiction. There is a lack of jurisdiction there. To say that this is not a dismissal for lack of jurisdiction, I think also ignores the realities of the federal rules, which allows the federal court to dismiss those state law claims so they can be better decided by the state law courts, as Justice Standridge had pointed out. I think because of that, Stanfield and Roden both now interfere with the operation of 28 USC 1367, and that federal courts are going to be reticent about dismissing state law claims if they're wanting them dismissed without prejudice so that they can be refiled, but they know that these decisions are out there in Kansas, which will then force the federal courts to keep those cases in federal court and to be decided by federal court, even though they are now state law issues. So I think that this is a jurisdictional issue. I disagree with Mr. Cooper that this is not a dismissal for lack of jurisdiction. I think it very clearly is a dismissal with, for lack of jurisdiction, because again, when you look at the timing, the court has dismissed the federal claims. Then it dismisses the state law claims based on its refusal to exercise jurisdiction. So it's no longer going to allow jurisdiction to be applicable in this case. And that's outside of the control of my client in this case and other plaintiffs that are like her. So I think that when the court's looking at those issues, they have to take that into account. And particularly when it comes to the supremacy clause, when we are essentially the only state in the country that are forcing these cases to remain in federal court rather than be decided appropriately based on Kansas law by Kansas state courts. I think that Justice Segal, you're the one that had asked about the application of whether or not this is federal law or state law. The best way I think that I can put it is that this is the state court's application of federal law, that Roten and Stanfield have become state law, but are applying incorrectly, in my opinion, federal law and the preclusion effect of a dismissal without prejudice. I hope that answers your question, Justice.
It does partially. Just a quick follow-up. Do you know of additional Supreme Court case law or holdings that go beyond what the court said in Heck, that state courts have to apply federal law on federal court decisions as it relates to federal questions or questions of federal law? Because I just don't think that extends to this situation, which is a dismissal without prejudice on state law questions.
Your Honor, I think that in Justice Atchison's decision, I think that there is a long list of cases in there where he says case authorities recognizing that aspect of res judicata are legion. And it starts with United Mine Workers and goes to a long list of different federal cases that I think would much
So
better.
you're just referring me to that as you think that goes beyond what the court in Heck said. And you may be right. That's a genuine question. I don't know the answer.
I think it reiterates and reaffirms and solidifies what is said in Heck.
Thank you.
If I'm understanding them correctly, Your Honor. At the end of the day, Your Honors, it does, in my opinion, come down to fairness. And with all due respect, Justice Files, I understand your position, but I think at the end of the day, our courts are supposed to allow claims to be heard on the merits. And to say that we have had a complete hearing on the merits of this case, even though the state law claims were not heard, is just not it's just not fair to my client, because it's not a true and accurate representation of what the law says anywhere else in the country. It's an aberration, in my opinion, here in Kansas that we're dealing with that goes back to Stanfield. And I think, as Judge Atchison points out, and as we argue in our briefs, the failure to continue that analysis of restatement judgment 24 and 25, and then including 26, I think is why we ended up here. We ended up with this offshoot, because prior to Stanfield, of course, we had Jackson Track. And that case, I think, accurately depicts what res judicata is supposed to be. Thank you so much for your time, Your Honors. It's been a pleasure. And unless you have any other questions, I will be finished. Thank you.
I don't see any other questions. So thank you to both counsel for your arguments today. We will take this appeal under advisement. The court is now in recess until 1:30 this afternoon.